tribunal now rules is irrelevant. But we had no opportunity to object to it. The tribunal had no opportunity to rule upon it. Had counsel asked, did you ever hear of the United States publishing its statements of mobilization? Of course, we would have objected. The difficulty is that the tribunal loses control of these proceedings if the defendant, in a case of this kind, where we all know propaganda is one of the purposes of the defendants, is permitted to put his propaganda in, and then we have to meet it afterwards. I really feel that the United States is deprived of the opportunity of effective cross-examination if this is the procedure.
Surely it's making too much of a sentence which the witnesses said about whether the United States makes its mobilization orders public or not. Surely that's not a matter of any very great importance.
Let me agree with Your Honor at once.
Every country keeps certain things secret. Surely it would be much wiser to ignore a statement of that sort. But as to the general rule, the tribunal will now consider the matter. I have already laid down what I believe to be the rule, and I think with the assent of the tribunal, but I will ascertain.
Let me say that I agree with Your Honor that as far as the United States is concerned, we're not worried about anything this witness can say about us. We expected plenty. The point is, do we answer these things or do we leave them? The point is the control of this trial. And it does seem to me that this is the beginning of this trial getting out of hand, if I may say so, if we do not have control of this situation. I trust the tribunal will pardon my earnestness in presenting this. I think it's a very vital thing.
So I've never heard it suggested that a counsel for the prosecution had got to answer every irrelevant observation which is made in cross-examination.
That would be true in a private litigation. But I trust the court is not unaware that outside of this courtroom is a great social question of the revival of Nazism, and that one of the purposes here of the defendant Goering, I think he'd be the first to admit, is to revive and perpetuate it by propaganda from this trial table if possible.
Ich wollte nur Folgendes erklären. Es wurde hier der Vorwurf erhoben, als ob etwa Propaganda gemacht werden solle für den Nazismus oder für eine andere Richtung.
It is that the rule which it is laid down is the only possible rule, and that the witness must be confined strictly to answering the question directly where the question admits of a direct answer, and that he must not make his explanation before he gives a direct answer, but after having given a direct answer to any question which admits of a direct answer, he may make a short explanation, and that he is not to be confined simply to making direct answers, yes or no, and leaving the explanation until his counsel puts it to him in re-examination. As to this particular observation of the defendant ought not to have referred to the United States, but it is a matter which I think you might well ignore.
I shall bow to the ruling, of course.